Good morning, participants to this webinar. I think we apologize for the few minutes, being a few minutes late in starting, and thank you for your patience. We will wait a minute more. I see some people are just entering, but you are with us at the Center for Human Rights, looking at the challenges of hyperandrogenic women in competitive sports. We have a wonderfully assembled panel that will speak to the issues arising. I think the background for most of us is not really something that is required to be reiterated here, but just to say that I think in 2019 we had what is now World Athletics issue the eligibility regulations for the female classification athletes with differences of sex development. And the perception was created that this was, in some sense, targeting a particular athlete, the South African Olympic 800 meters champion, Caster Semenya. So this morning's session is, on the one hand, looking at this issue more holistically, generally, but it is informed by the particular case of Caster Semenya. So we want to explore the issues, but we will also make reference to the specific instance that kind of brought this to our attention. So as usual in these webinars, I ask our participants please to mute your microphones and close your videos so that we don't take up bandwidth, but we ask you please to consistently add your voice in the chat room. You're most welcome to give us comments and questions. How we intend to proceed: we will allow each of our panelists 10 minutes to introduce aspects of the topic. Thereafter, I will choose from the questions and comments in the chat room and pose them to the panelists. They will briefly respond. Hopefully, we'll have an opportunity for people in the meeting to also participate. And at the end, we will quickly do a roundup. So at the outset, though, we have a poll. We ask our participants, please, a poll will now appear on your screen. And we ask you to please complete this poll. It is just basically asking you to indicate how you came about to be interested in participating, in attending this. So you'll see the question, what drew you towards today's COVID-19 or human rights talk? So it's not really COVID-19, that's generic. What drew you to this talk on the challenges of hyperandrogenic women in competitive sports? You have options there. You can choose any of those that apply. We give you a minute or two that just assists us also to plan for future events of this nature. So if you do us the favor of choosing your options and just submitting them as we start this event. And thank you so much for doing that as well. So without any further ado, we will start off our series of panelists with Bianca Kapp. She is an attorney here in Pretoria, in Centurion, with C4 attorneys. But most importantly for our proceedings today, she is a researcher on female athletes with differences of sex development. So Bianca will speak and give our discussion context, and she will focus in particularly on the medical aspects as they pertain to female athletes in this category. So thank you very much, Bianca. And please, we ask the speakers to keep to the 10 minutes maximum so that we can have an opportunity for discussion afterwards as well. Over to you, Bianca. Thank you so much.
Okay, perfect. And welcome to all that's listening. I'm just going to jump right into it. So World Athletics, formerly known as IAAF, as we have now come to know them, faced constant pressure from society to take action against presumed unfair advantages by athletes such as Caster, who came onto the scene in the 2008 Beijing Olympics. And most of the pressure they received was from the athletes themselves, saying that they cannot run with these type of people. When the pressure amounted, the IAAF took recourse and enforced the prior hyperandrogenism regulations, but only later on did they say that World Athletics stated that the athletes' rights for sport, fair sporting practices is the reason behind the regulation itself. And then only later on did they produce what they perceived as strong medical proof. But before we get into that, let's first try to understand what we are dealing with. Over the last few years, World Athletics has familiarized the public with two terms in relation to athletes like Caster Semenya and Dutee Chand, being hyperandrogenism and DSD, which is also known as differences of sex development. Now, the first regulation focused solely on regulating hyperandrogenic athletes, such as Caster Semenya, in competing in elite competition. Hyperandrogenism is a medical condition where a female naturally produces higher levels of testosterone than an average female. This has also become known as the condition of athletes such as Dutee Chand and Caster Semenya. Now, the hyperandrogenic regulations were first scrutinized by medical professionals and human rights activists, while the regulations were appealed by Dutee Chand's legal team. World Athletics ended up retracting what was already considered a weak regulation, and they replaced it with the current, and in my opinion, even weaker DSD regulations. The DSD was formerly known as a term that we may have heard more, intersex. It is the mismatch between a person's chromosomes or genetic material and the appearance of the genitals. And now, as many of you may know, the age-old medical discovery classified male as having an X and a Y chromosome, and females have two X chromosomes. And up until present, very little provision has been made for the combination of other chromosomes. Now, DSD can take forms of various different conditions and syndromes linked to the sexual organ, which is why hyperandrogenism is regulated thereunder. One of the most relevant syndromes is androgen insensitivity syndrome, where females actually do have a Y chromosome that's typical of male, but the body does not respond to that the testosterone produced. They develop and often identify as women. With this said, and with the very limited scientific proof that currently exists that athletes have any sort of an advantage over an average athlete, there is still a lot of people that constantly dramatize and criticize hyperandrogenic and DSD athletes. Now, in spreading awareness of DSD, I thought the best way to approach this situation and this topic would be to answer the two most frequently asked questions by me in my 5 years of research in DSD. These two questions are: does DSD provide its holder with athletic advantage? And what is the scientific proof behind DSD? Let's start with the first question: does DSD provide its holder with athletic advantage? Now, I cannot begin to describe how many times I've been asked this question, how many times people have tried to fight me on this question, but I have a very simple answer. I am not a medical professional, and therefore I cannot give you an upfront yes or no answer, but I am a legal professional, so I will give you the legal answer, which is innocent until proven guilty. And in Caster's situation, I would say, until they can prove that she does receive an advantage from this internal testosterone that is naturally produced, we cannot regulate her and keep her liable for something that we don't even know if that is possible. In the original Chand case, where Chand's legal team basically tore the World Athletics defense apart by simply requesting proof that higher levels of naturally produced testosterone actually provides its holder with athletic advantage in any shape or form. I specifically remember thinking, and I still wonder about this, how it is even possible that in such a technologically advanced era, there's still such little relevant scientific proof that exists that females with higher testosterone levels have any sort of a sporting advantage over an average female. And I will touch on that in answering the second question. But let me try to dig further into this medical phenomenon as we know as DSD. As I have mentioned before, I'm not a medical professional, and but I have conducted extensive research on the medical side of the DSD, and I will try to simplify the complexity behind DSD, specifically in trying to prove that testosterone provides the athlete with an athletic advantage. Now, it is such an intricate process because we know the testosterone exists in the body, but there are so many binding processes that need to take place. It's like 6 or 7 that needs to take place for the body to actually utilize that testosterone. And when even one binding is inactive or does not link properly, such as inactive receptors in the body, then the body is unable to use this hormone and rendering basically null and void as if it was never present in the body in the first place. And that is just the tip of the iceberg, really, because it's so hard to actually test for this, because in current testing for anabolic androgenic steroids, the synthetic anabolic steroids that we put into our body is detected with great success. But the actual testosterone that is developed internally, the endogenous steroids, is undistinguishable. It doesn't have identities that we know currently or the capability. So we don't currently know what it even looks like. Think of it like this. When testing for something specific, it's very easy to pinpoint what it looks like and what the effects of it is. But if you don't know what something looks like, and if you don't know what its effects is, then it is very difficult for one to actually identify the presence of that athletic advantage. Let's move on to question 2. What is the scientific proof behind DSD? As I've mentioned before, it is hard for me to even fathom that such little evidence exists on this matter. And actually, the only published proof that currently exists that there may be an athletics advantage is what I refer to the Berman tests. And they were conducted for means of the World Athletics, specifically for the Caster Semenya case of 2019 last year. In short, the tests supposedly prove that women with higher testosterone levels gain an advantage, but only in the 5 following events: in 400-meter sprint, 400-meter hurdles, 800 meters middle distance, hammer throw, and pole vault. Now, if you consider this and you're wondering why World Athletics actually included 1,500 meters into the regulation, if the regulation was based on the Berman tests, let's just say they threw it in there as a bonus. The tests, however, were proved to be of a very poor standard, and they were very flawed. The data used in conducting these tests actually consisted of several times that were duplicated. So you'll have several athletes with exactly the same time. You also had athletes that were duplicated. So the same athlete with the same time was entered into the database more than once. And then we had phantom times, times that were included into the data set, but they had no identity of an athlete linked to that time. On top of that, the set of data was also inclusive of Russian athletes that were involved in the global Russian doping scandal. Based on this, it is my opinion that concurrent to the nullification of the DSD regulation, all regulatory bodies, no matter its power or status, should be subsequently barred from promulgating successive regulations relating to hyperandrogenism and DSD until such a time where conclusive scientific evidence can be provided that proves the existence of a profound sporting advantage held by hyperandrogenic and DSD athletes.
Thank you very much, Bianca, for that very, I think, well-informed and insightful presentation that really forms the basis for our discussion. Much appreciated. If you just joined us, welcome to this discussion. We go to our second speaker in the panel, and that is Professor Steve Cornelius. He is the head of Department of Public Law at the University of Pretoria Faculty of Law, but he most importantly also served on the IAAF IAAF's Disciplinary Tribunal, and he stood down from that position in the wake of the Caster Semenya situation or saga. Thank you very much, Professor Cornelius. He will speak more about the legal issues involved. As I think most of us know, there are two courts really that came into play. Well, the first is the Court of Arbitration for Sport, which has dealt with the issue, has taken a decision upholding the regulations, as we know. At that court, because it is based in Lausanne, Switzerland, its findings can be appealed to the Swiss Federal Supreme Court, and the matter then is pending an outcome as far as this appeal is concerned. But to talk more about these legal avenues and the legal issues involved, it's over to you, Steve, Professor Cornelius, and thank you so much for joining us.
Thank you, Professor Viljoen, and thanks for inviting me. I think Bianca gave a very good summary of the science, and I think she, like Professor Ross Tucker and the others who questioned the science, is kind by simply questioning it. I think if one looks at it, we can just call it fake science, because there's really so much going on and so many flaws that have been identified that it's a clear case of science being created to suit the purpose for which it is created. And it really, in scientific circles, it's not seen with any authority. It's really been discredited. But just getting to the legal side, in most sports, there is this binary distinction between male and female events. And this arose around the 1920s, when there was a feeling that sport should not just be for male competitors, but should be more inclusive. And it was a long journey. In many sports, even athletics, there is still not 100% parity between the two competitions. So for instance, in women's events, up to the 1984 Olympic Games, no woman had run further than 800 meters. The 1984 Olympics was the first time that there was a women's 3,000 meter race and a women's marathon, for instance. And similarly, even today, the men, for instance, in the multi-event competition would do a decathlon, which is 10 events, whereas the women do a heptathlon, which is only 7 events. And then some of the longer distance, especially walk events, and so there's still disparities. So the claim is that there's this attempt to have this equal playing field so that men and women can both participate. The problem that you face when you have this binary distinction is that there is no scientific way where you can draw the line to say this is where male ends and this is where female begins. And that is the problem that the IAAF have been grappling with since the 1920s. So in fact, they have had various attempts to try and what they call safeguard female participation and protect women so that men don't pose as women and participate. Now, there's only one instance where this is actually known to have happened, and that was in the 1936 Olympic Games, where the Nazis tried to cheat and enter a man into the women's high jump. And it in any case backfired on them as well, because the gentleman was so embarrassed at what he had to do that he underperformed and finished 4th. So they didn't even achieve anything with that. The issue of hyperandrogenism also dates back to the 1930s, 40s, where there were issues with some of the athletes, particularly a Dutch athlete called Fouquier Delama. And there were questions, and she was eventually banned from participating. Now, the IAAF tried to resolve this in a number of ways. The first way they did was what they called a naked parade, and it meant that women who wanted to participate at international level literally had to strip naked in front of a panel of medical doctors. And I can only assume in the 1930s, 40s, 50s that this would be an all-male medical panel. strip naked and then be examined and cleared to participate, which I don't think anyone has to say how humiliating and outrageous this is. So eventually they realized we can't continue with this process, and they then moved to the chromosome test. And as Bianca has already indicated, the chromosome test has been discredited. Actually, from the outset, there were scientists who said that chromosome is not the only indicator, and there is no clear-cut distinction with chromosomes, because some people have 3 chromosomes instead of the 2. And then you also have a mosaic chromosome where, depending on which cell in the body you test, you might either get an XX or an XY. So fairly quickly it became apparent that the chromosome test was really not appropriate. The IAAF then, I think, let the matter rest for a while until Ameermia came onto the scene, and then because of a few athletes and a few media outlets that made a fuss of this young girl from South Africa or Africa suddenly bursting onto the scene and running away for everybody, created what they perceived to be an embarrassment. And they then started to look at testosterone as the marker. But again, the problem is that testosterone does not determine sex or gender. There is no unique specific male level, as the IAAF tries to claim. They set the male level at, let's say, 10 nanomoles per liter, but there is no unique male level. And in fact, in some of the tests that the IAAF conducted, some of the male athletes who won medals at the World Championship or Olympics were actually hypoandrogenic, which means they have extremely low testosterone levels. And the fact is that in adult males and females, there is absolutely no scientific proof that endogenous, in other words, produced by the body, testosterone impacts on performance. There's a ton of medical proof that it impacts on performance during puberty, but not during adult performance. So there's no indication that reducing the testosterone will change the performance because of the testosterone. Obviously, reducing the testosterone has an impact because of hot flushes and all kinds of side effects the athletes have to the medication. So the first set of regulations basically covered all women. That was what we thought at the time fairly successfully challenged by Duty Chand in the Court of Arbitration for Sport. But in hindsight, I think it should have been clear even then that the Court of Arbitration for Sport was not going to side against the IAAF. They should, in the Duty Chand case, already have said this is nonsense, it should be stopped, and we're not going to entertain it further. Instead, they gave the IAAF an opportunity to revise the regulations and come up with new proof and resubmit. And again, with hindsight, and hindsight's an exact science, but there were things during the hearing which made it fairly clear that at least 2 of the panel members were not going to decide against the IAAF, and that they had already made up their mind as to the legality of these regulations. So currently we are waiting for the Swiss Federal Tribunal. We have no indication when they will come up with a ruling. In terms of the Swiss Private International Law Code, they should already have rendered a decision, but clearly there are issues that they are deliberating and discussing amongst themselves, and we will have to wait and see what the outcome of that is. Just as a last point, because I see my time is running out, the major arguments that Athletics South Africa made in its case, because remember it was challenged by Ameermia and Athletics South Africa, was a huge human rights case specifically relating to the European Convention of Human Rights, because Monaco, where the IAAF is situated, is a signatory to the European Convention on Human Rights. So the argument was that it violates the right to human dignity, the right to your family life, which in the European context has quite a broad interpretation, and obviously also discrimination. And the Court of Arbitration for Sport never even touched on those, except indicating that, well, it is discriminatory, but we don't think it's unfairly discriminatory. And that is effectively what the Swiss court is now asked to decide.
Thank you very much, Steve, for that very insightful and also thought-provoking presentation, giving us the background from the legal perspective in a broader context. I know our sequence, Commissioner Ameermia, indicates that you are the next speaker, but I must implore your indulgence to allow Joshua Sehoole, because he's indicated that something came up at the last minute. So we will ask Joshua, and then we'll come to Commissioner Ameermia. So Joshua Sehoole is a human rights activist. He has served as the regional manager of Iranti, which is an organization that advocates for the human rights of sex, gender, and bodily diverse communities. He also served as the board member of Gender Dynamics. He's a student of international politics, and at the moment he's actually studying human rights and democratization in Africa with us at the center. So thank you very much, Joshua, for agreeing, and over to you to give us the perspective from a human rights kind of activist point of view.
Thank you, Prof. Yeah, what I want to touch on is just the kind of general theoretical and social underpinnings around how we view gender, how we view sex. So what the case around Casta really shows is the way in which sports is a microcosm of the impact of arranging society according to gender. And this case kind of shows the fallacy of a binary system and the consequences of treating it as an objective standard of arrangement. Typically, we see sex as biological and divided into two clear categories, male and female. And as Prof. Cornelius said, what we're looking at rather is, in terms of what sex actually is a spectrum, is a wide spectrum upon which we've made societally determined divisions. So where one puts the line of where male and female is not just a purely kind of objective scientific exercise in the way that people think of science as being completely absent of any kind of subjectivity. And I think that the IAAF regulations and the medical approach in this regard is not restricted to sports and athletics, but is reproduced and replicated generally in the way that the medical field views and engages and interacts with the notions of sex and gender. So when you look at how we view medicine, and when you look at how these categories are kind of codified or looked at, there's we of course have in terms of the human rights framework, we have the World Health Organization, and the World Health Organization is the entity that develops a classification, a kind of classification code around health and illness that is called the International Classification of Diseases. And this is kind of the international medical language that doctors would use to speak to other doctors about health and illness in the human body. It is very, when you look at the ICD and the kind of notions that have come from the ICD, you can see, for example, a history of pathologizing difference. So pathologizing diversity and difference just for not necessarily looking at illness, meaning looking at something that within someone's body will give rise to something that needs medical attention, but merely noticing difference and taking that difference and constructing and conceptualizing it as disordered. And this can be seen, for example, when you look at how at a certain point homosexuality was codified in the ICD as a mental illness, as an indicator of something that is disordered. You can see it in the way in which historically medicine and science has employed racist tropes to try and paint Black people as somehow less intelligent, using medicine to kind of justify slavery and racism at different points in history. You can see it around the treatment of women, around the assignment of the diagnosis of hysteria to women who weren't seen as meek and submissive enough, who weren't seen as existing within the prescribed role that women have been given in society. And so when you look at the way that gender is classified, sex is classified, race is thought of, and all these different components that are related to the structural systems of oppression that operate in the world, you do need to take a step back and acknowledge that medicine and science does not exist in a vacuum, but exists within a society with existing prejudices, and that those prejudices impact on the way in which medicine and science kind of is thought of and operates. So from that perspective, when you look at the way in which gender and sex and those categories are created and exercised, then and when you look at diversity, even the language we're using on this call in terms of disorders of sex development, and what is decided to be disordered, you do need to look at, who pathologization serves and whether there is any actual medical need that would create kind of a justification of seeing something as being problematic or a malformation or a disorder in and of itself. So I just wanted to bring that to the conversation in terms of the framework of knowing that we're using. And I think that another thing I just want to briefly touch on is the unequal way in which these regulations are being applied to female versus male athletes. I think Prof. Cornelius already spoke about the way in which certain male athletes have lower levels of testosterone than average, and Bianca also touched on the flawed methodology, the discredited methodology of the Viljoen study, and the wide questioning of its validity, and the cherry picking of the IAAF of a few specific events, and the selective application of the restriction that really does point to targeting specific athletes in a way that's going to disproportionately affect women of color from the global south. And when you look at the way in which, I mean, I think if the IAAF wanted to claim to have some kind of non-discriminatory applicable approach, then, you know, one does need to question, you know, if men are being shown to have a statistically lower level of testosterone, why they are not being given the leeway to take more testosterone, so that they are within, you know, so that they have a similar, so that there's no unfair advantage, and why this has been exercised in terms of women's bodies specifically. And I think we live in a society and in a culture where there is an increased monitoring and around women's bodies generally. Yeah, so I think those are just some of the points that I want to touch on. Lastly, just quickly, if I could, I think that there's a very arbitrary way in which testosterone and sex characteristics are being singled out. When you look at sports and what sports is and what competitive sports is, it's about testing the limits of the magnificence of the human body in its natural state. Who is faster? Who can throw further? Who can carry more weight? You know, one would definitely see a request for basketball players that are too tall to kneel down so that they don't have a competitive advantage as ridiculous. Or when one looks at how Michael Phelps is seen to is double jointed and has almost like this flipper-like you know, movement when he moves through the water, or Usain Bolt being the longest, the tallest runner. You know, no one would look at kind of controlling those natural physical factors that give them a competitive advantage from people who don't have those physical factors. And this is no different to casta, even if it does confer some kind of advantage. So I think we just need to critically think about the entire framework. Thanks.
Thank you so much, Joshua. And please stay on. Maybe we could get you to also engage with the questions, but we also understand that when you have to excuse yourself, that will have to happen. So we move on to Commissioner Ameermia. Advocate Ameermia is, as many South Africans know, a member of the South African Human Rights Commission. He's been elected to that in 2014. And he serves as a full-time member responsible in particular for housing, water, sanitation issues. He also serves on a number of boards, including the board of the Center for Diversity Studies at the University of the Witwatersrand. So Commissioner Ameermia has been quite vocal and involved in this. Before I introduce him to speak about the kind of South African response and with a focus on the response of the South African Human Rights Commission, I just also take the opportunity to welcome one of his colleagues, a member of the South African Human Rights Commission, Angie Makwetla, who is also with us in the audience. Welcome, and over to you, Commissioner Ameermia.
Thank you very much, Professor Viljoen, and to the team. It's an honor to be here. I just want to also add that, you know, as part of my mandate, it is also, I have been mandated on access to justice, as well as business and human rights, and I serve on those committees at the United Nations, you know, the special rapporteurs, technical working teams on that. And that's how I came into being very much interested in the Caster Semenya matter, because we think that there are fundamental issues around the broader human rights violations taking place in the business and human rights space. So thank you very much for everybody else's input. And I'm not going to touch on what they've said, but I'd like to just add on from my side, just 8 points, which I think can add to a discourse where we can find a just solution you know, to the plight of Caster Semenya and many like her on the African continent and in the developing world, where similar athletes find similar discriminatory practices against them, but are too scared to speak out against it. Caster was one of them, and we must, you know, commend her for a fight in this regard for the past 10 years that she's been on the case of the IAAF as well. It has taken a toll on her personal life itself, and we think that justice should be, you know, level the playing fields by now. So thank you on behalf of the Human Rights Commission for having us here. Commissioner Makwetla and I are particularly interested in this because we have teamed up with the Commission for Gender Equality on this matter. And we've been working very closely with the Center for Sports Forum in Geneva, as well as with Norton Rose Fulbright, who are Caster's lawyers in this matter. We think that there has to be a greater response advocated from South Africa, particularly because South Africa chairs the AU, as well as sitting on the Security Council of United Nations, and they are very, you know, championing human rights even at the mission in Geneva itself. Sports, I've got 8 points to make, Chairperson, and I'd like to just basically say from the outset that sports can be a unifier. It's a tool that can unite people across race, creed, color, and religion, and inculcate shared values of diversity, equality, tolerance, and fairness. The Sustainable Development Goals highlights, the agenda highlights the importance of sports as an enabler of peace and development. But we, as I said earlier on, we also know too well that sports has negative outcomes as well. We know, for instance, where athletes have faced human rights violations at the hands of sporting federations. Now, the United Nations Human Rights Council in a resolution expressed concern on discriminatory regulations, rules, and practices that may require women and girls athletes with differences of sex development, androgen sensitivity, and levels of testosterone to medically reduce their blood testosterone levels. The Human Rights Council noted that such discriminatory regulations do, and I must emphasize, do contravene international human rights norms and standards. And I basically highlight 8 of those: the right to equality and non-discrimination, the right to the highest attainable standard of physical and mental health, the right to sexual and reproductive health, the right to work and to the enjoyment of a just and favorable condition of work, the right to privacy, the right to freedom from torture and other cruel, inhuman, and degrading treatment and harmful practices, and full respect for dignity, bodily integrity, and bodily autonomy of the person. Now, equally so, from a business and human rights perspective, states have a duty to respect, protect, and fulfill human rights. The state should do everything in their powers to ensure that sporting associations, federations, and bodies do not violate international human rights norms and standards in policies, practice, and standards they develop. The rules and codes of practices that coerce women athletes to undergo testing which is humiliating, demeaning, invasive, and potentially harmful falls afoul of human rights standards and infringes the right of female athletes to bodily integrity. Whilst the South African government has to be commended for attempting to champion the quest for Mohamed Caster Semenya in the fight against discriminatory regulations by the IAAF, the South African government, as we know, co-sponsored the United Nations Human Rights Council resolution, which I cited above, Resolution 40 of 2019. However, the South African government could and should do more within the space of the Human Rights Council to ensure that these archaic and discriminatory regulations are repealed. And especially now, we should be taking advantage of the fact that we are now chairing the African Union as well as we have a seat on the Security Council. So we are a serious actor on the global plane. Now, the South African Human Rights Commission is a national institution embedded in the Constitution in terms of section 184 in Chapter 9. And we are tasked with protecting, promoting, and monitoring human rights. And as such, we have a constitutional duty to ensure that the state and non-state actors respect and comply with human rights standards. Women and girl children battle with multiple and intersectional forms of discrimination which inhibit the attainment of gender equality as well. So what I'm saying in the last point I'd like to make on this, Chair, is that the South African Human Rights Commission plans to work with the Commission for Gender Equality another Chapter 9 institution to complement the efforts of the South African government ensuring respect, protection, and the fulfillment of gender equality in sports. And the South African Human Rights Commission and the Gender Equality has used the United Nations Human Rights Treaty system, will continue to use this fora to champion issues of gender equality in sports. And we encourage non-government organizations should also galvanize the efforts to lobby for the repeal of discriminatory policies and practices which continue to reinforce unfair discrimination. What I'm basically saying in conclusion, Chairperson, is that it is now time that we stand up for our rights, for human rights against such indignities. We should do so in a smart way, and this is what we should do, complement all our skills that we've just heard today, and do a strategic collaborative partnership to ensure that Caster Semenya and many other athletes from the developing countries and anywhere in the world, given that we as a Human Rights Commission have an A accreditation status at the Human Rights Council, to ensure that justice will be meted out fairly and equally. I thank you.
Thank you so much, Commissioner Ameermia, for those, I think, very thoughtful reflections that will also guide us in the discussion. Let me just reiterate to the audience, to the participants, that you're most welcome to just in the chat box pose a question or make a comment. We will also try to see if there will be opportunity to take the floor, but for the moment we welcome your contributions. As we move to our last speaker in the sequence of our 5 panelists, who is Tapiwa Mamhare. Tapiwa is a doctoral candidate. He is researching on the rights of persons with differences of sex development, and he has been looking at ways in which strategically the issues pertaining to DSD could be raised also within the African Union human rights, regional human rights system. But I think for today, Tapiwa will reflect a little bit on the avenues that could be open. Professor Cornelius talked about the case that is pending before the Swiss Federal Supreme Court, perhaps anticipating an unfavorable outcome, not to say that it would be, but if it would be the case that the matter is not resolved favorably in Caster Semenya's favor, what would be some of the options that are open from a legal point of view? So Tapiwa will briefly speak to these kinds of options that are available.
Okay, thanks very much, Frans, and hi to everyone. So as Professor Frans has already mentioned, I've been tasked to speak on the avenues in the international human rights framework that can be used in the event that there's an adverse finding by the Swiss Supreme Court. So to start with, anticipating an adverse finding by the Swiss Supreme Court, confirming the ruling that was done by the Court of Arbitration for Sports, there are mainly 2 avenues that can be used to master international pressure. The first one is within the Council of Europe. This is within the European human rights law framework. Then also the second one will be within the United Nations. That is through the United Nations Human Rights Council, and also through the use of the human rights treaties and the treaty bodies. So Switzerland is already a member of the Council of Europe, and it is also a state party to the main human rights treaty within the Council of Europe, and this is the European Convention for the Protection of Human Rights and Fundamental Freedoms. So under this option, what can be done is to submit a case to the European Court for Human Rights, which is mandated with monitoring the implementation of the European Commission. So should the Swiss Supreme Court give an adverse finding, the European Court for Human Rights can be approached based on the European Convention. So procedurally, this would likely be successful, but domestic remedies have to be exhausted first. And in this case, exhaustion of domestic remedies will be signified by the decision of the Swiss Supreme Court, which is actually the last step or solution within the jurisdiction of Switzerland. So it is also important to mention that before, the European Court has previously found Switzerland in violation of the European Convention in respect of a decision which was actually done by the Swiss Supreme Court. And this case actually related to sports issue as well, as the ruling had been done by the Court of Arbitration for Sports. So when the European Court is approached substantively, strong arguments can actually be made, and but the success of these arguments is not guaranteed. But just to mention some of the relevant rights that that are violated, and also which have been mentioned by Commissioner Ameermia. These are Article 3 on freedom not to be subjected to torture, inhumane or degrading treatment, Article 14 on non-discrimination, and Article 8, which provides the right to private life, stipulating that any limitation to that to those rights must be shown to be necessary in a democratic society. So these are all rights which are contained in the European Convention, which are potentially violated by the IAAF regulations against women with hyperandrogenism. Further, the European Court has also interpreted the right to private life as guaranteeing physical, moral, and psychological integrity. And with respect to physical integrity, the regulations obviously violates the physical integrity of Caster Semenya and other female athletes as well who are in the same situation, because the regulations actually do not protect the principles of informed consent, because when these athletes are subjected to these medical tests and also these processes of reducing their testosterone levels, it is done without their consent, because they have no option. They have to reduce the testosterone levels for them to participate in the highlighted sporting events. So in deciding the Caster Semenya issue, the European Court is also likely to recognize the relevance of private life jurisprudence, and it could also take a strong position against discrimination based on gender stereotyping. But also it is imperative to highlight that the European Court has also, under similar circumstances, frequently invoked the margin of appreciation doctrine. So under this doctrine, the European Court defers to the judgment of national institutions, including the courts as well. So this is mainly done, especially where there is no European consensus on a particular issue under consideration. So if the European Court is to adopt this approach in the present case, the European Court will not find Switzerland in violation of the European Convention. Then the second option that I mentioned, besides the Council of Europe, is under the United Nations Human Rights System. So under the UN Human Rights System, there are two main broad options. And these are within the more politicized arena of the Human Rights Council, which is the most prominent forum where the discussion of human rights issues is done. Then also there's the quasi-judicial forum of the UN Human Rights Treaty bodies. Under the Human Rights Council, the first thing that is done there is as we all know, the Universal Periodic Review, the UPR. So under the UPR system, fellow state representatives every 5 years assess the human rights record of a particular country. And this particular instance, the human rights record of Switzerland, can be assessed. But unfortunately, the last review of Switzerland was in 2017 in a cycle which ends in 2022. So this means that at this particular moment, UPR cannot be used to raise the issue of Caster Semenya, because Switzerland will only be next assessed in 2022. Then also we also have the UN human rights special mechanisms, which were also mentioned by Commissioner Ameermia, is established under the UN Charter, and these also report to the UN Human Rights Council. For example, we have the Special Rapporteur on the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. Then also we have the Special Rapporteur on torture and other cruel, inhuman, or degrading treatment or punishment. And it is important to highlight that these special mechanisms have actually made pronouncements on this particular issue. These mandates have expressed the view that scientific concerns cannot take precedence over enjoyment of human rights or human rights violations. It is also imperative to also mention that the Human Rights Council is also a space for debate where human rights resolutions can be adopted, and the Human Rights Council has actually adopted a resolution on this issue, which was actually titled Elimination of Discrimination Against Women and Girls in Sports. Then the option of treaty bodies. The UN system also has a number of treaty bodies that can be approached to consider the Caster Semenya issue. And just to highlight a few, there's the Committee on the Elimination of Racial Discrimination, Committee on Elimination of Discrimination Against Women. There's also the Committee Against Torture, Committee on Economic, Social, and Cultural Rights. We have the Human Rights Committee. Yes, so those are some of the treaty bodies that can be approached on this issue. However, Switzerland has not agreed to some of these treaty bodies. So treaty bodies may examine individual complaints in respect of state parties that allow for such a process, but then this is also optional. And Switzerland has not done this in respect of the ICCPR and also the ICESCR. And so the possibilities in regards to this are very limited, and also the decisions are non-binding, and also the process can also be very protracted. Treaty bodies may also examine state-to-state communications. So in this instance, South Africa and Switzerland have both accepted the state-to-state procedure under CAT. So South Africa would therefore submit a complaint against Switzerland that the CAS decision is confirmed by the Swiss Supreme Court disregards the human rights of Caster Semenya, and which is actually a violation of anti-CAT, as this has been regarded as torture. So this is an option that could be used as well. It is also important also to highlight that under Article 22 of the CERD and Article 29 of CEDAW, a process of arbitration between states is also allowed, with the possibility of also approaching the International Court of Justice if attempts at arbitration fails. So lastly, treaty bodies also regularly, like every few years, examine periodic state reports and issue concluding observations. And so far, none of these concluding observations concerning Switzerland have addressed this issue. So in conclusion, I have raised 3 options which can be used complementary to each other. And the first one is judicial in nature. As I highlighted, a case can be submitted for a decision by the European Court of Human Rights. The decisions of this court are binding, and also they are most effectively implemented. But a positive decision, as I have highlighted earlier, is not guaranteed. And the second one is quasi-judicial in nature. And this is through attempting to secure a finding by a human rights treaty body in respect of an individual communication or a concluding observation. Then the third and last one is diplomatic, political in nature, and this is by leveraging the UN special procedures or resolutions of the Human Rights Council and the UPR. So it's already been mentioned by the other speakers that these have to some extent been already used, but then they could also be further used and explored. Yeah. So lastly, the South African government can also take up this issue again within the Human Rights Council itself and can raise these issues. With that, I conclude.
Thank you. Thank you so much, Tapiwa, also for sketching those alternatives. And I think most of you may have noted that the Court of Arbitration for Sport sat with 3 members and it gave a majority opinion. So clearly the opinion was divided 2 against 1. So that would suggest that there was at least some internal disagreement. But from what one sees, the appeal to the Swiss Federal Court is not so likely to succeed. From what one reads is that in the 35 years, 210 such cases came to appeal before the Swiss Federal Tribunal, and very few, around 10, had ever been successful, mostly on the grounds of lack of jurisdiction or grounds of procedural irregularities. I think here the question is a substantive question, namely, is it against the public interest? Is it against ordre public in the French, right? Is it against public policy? So thank you, Tapiwa, for sketching those out to us. Tapiwa mentioned resolution 40/5 of the Human Rights Council, and I see Kalekei Kailo. I will give you the floor if I'm not surprising you too much. I see you posted a comment about that resolution. You are based at the UN High Commissioner for Human Rights. I would like you to make a brief intervention, Kalekei, if it's possible.
Thank you very much, Professor, and thank you for hosting this important discussion. My name is Kaleche Chalo, and I work at the Office of the High Commissioner for Human Rights. In 2019, the Human Rights Council passed a resolution on the elimination of discrimination against women and girls in sport and mandated the High Commissioner to prepare a report on the same issue to be presented at the 44th session of the Human Rights Council, which should start in approximately 2 weeks, I think, towards the end of June. And so, unfortunately, the report is not yet available online, but we discuss a lot of the things that have been shared by the panelists today with regard to how sport is divided, and when the eligibility regulations, it relies on stereotyping. And I have also posted a link of the special procedure mandate holders who wrote and told the Court of Arbitration for Sport that these regulations were in fact in law discriminatory against women with differences in sex developments or sex variations, intersex variations, and also informed the Court of Arbitration for Sport that, they were discriminatory in human rights and infringed on the right to privacy for the athletes involved. So the report should be online soon. I don't know when, but we have discussed like a lot of things that you have, you know, the colonial history, the human rights involved, and giving recommendations to sporting bodies and to states on what they could do to better protect athletes' rights.
Excellent.
That have been intervened.
Excellent. Thank you so much. I think that was very useful to know that the resolution was adopted, but now there's subsequent action, a report, and we will all, I'm sure, be watching out for that, and we'll try to share it in the network. I think you mentioned also the whole question of sports federations, and I want to go back to you, Steve, Professor Cornelius. I think you raised the issue of locating our discussion here in the broader issues of accountability, if you like, the rule of law, as it pertains to sports federations. I wondered if you would like to just briefly elaborate on that point and what the current situation kind of tells us about how important those issues are.
Thanks, Frans. I think the international sports federations tend to have a bit of delusions of grandeur, and they consider themselves to be on par with national governments and nation states. And we've seen in the past, I mean, with the Salt Lake City Olympic Games, the huge bribery scandals that arose there. We saw with FIFA where, due to US intervention, almost the entire FIFA executive was arrested, and directors were arrested for bribery. We saw with some of the construction projects for FIFA World Cup stadiums, the labor abuses that were reported around that. And there's almost a sense with international sports federations that they operate in a vacuum on their own. And that is one of the problems I have with the ruling of the Court of Arbitration in this particular case, is they tend to ignore national laws. The Constitution of World Athletics states expressly it is subject to the laws of Monaco. Now, if you're subject to the laws, it means you first apply the law and then you look further. The Court of Arbitration never even looked at the law of Monaco. The IAAF or World Athletics never made a representation on that. Athletics South Africa made huge representations on the fact that these regulations would not meet the standards set in the law of Monaco. So in other words, this idea that sports federations can, in a sense, contract themselves out of law by going to the Court of Arbitration for Sport and by relocating them at some time in jurisdictions where they felt less pressure. Because the IAAF or World Athletics is in Monaco because they were held to account in a British court. And the British are very reluctant to intervene with judicial review. And even in the British court, they came up short in the 1970s, and then they relocated. A lot of sports federations are in Switzerland because they felt they would not be interfered with. Some are in Dubai for the same reason. And I think this idea that sports federations can do as they please and that they're not subject to any legal system, that must be dispelled, and they need to be held to account.
Thank you very much, Steve. I saw in the chat box also a comment by Mercy Okiro. Mercy, if I could ask you also if you would like to take the opportunity to make a brief intervention to just locate our discussion in a broader Pan-African context. Mercy Okiro, please.
Good afternoon, everyone. I hope you can hear me clearly.
Yes, please proceed. You can also open your video if you have that capacity.
Yeah, 1 second. Sorry. Here we go. Oh, sorry. I'm wearing my glasses because, yeah, I think that's in order. Yeah.
Yes, please.
So yeah, basically, I just dabble in sports law here in Kenya. I'm an advocate. And I write articles on sports law. I was just trying to locate the link to my article. If I can't, I could probably share it to the organizers, then they can send it to the participants. We've also had issues of similar to Caster Semenya in Kenya. Two of our athletes, before she lost the matter at the arbitral tribunal, when now she appealed to the Swiss Federal Court and she got temporary relief, we had two athletes who had hoped to ride on that, our two relay athletes, they were hoping to ride on that temporary relief that she got, but then they were very particular, the Swiss Federal Court, saying that only Caster Semenya is going to take it up. But then for me, my thinking, and I'd like to just add what, and also agree with what other speakers have said before, this is not just an issue of Caster Semenya, sorry. It goes also into issues of discrimination for me, even in sports against African women. My argument in that paper was basically that if you want to say she's getting unfair advantage, then what about the other flip side of the coin where you realize that she's an athlete in Africa, she came from a humble background, and yet some people have been training a lot and they've had better facilities. So at what point then does discrimination, and this is natural, she was born like that. So when other sports people, maybe in Europe, get better facilities and they've trained in the world-class facilities from childhood, so at what point then do you say it's unfair advantage for them and for us? So for me, it also goes to issues of discrimination against African athletes. Another thing is I would like to say about intersex persons. The Kenya National Commission on Human Rights in Kenya, for me also, I said in my article that it's not just an issue of people like her who have more chromosomes or whatever. It is also an issue of intersex people in sports. This is a conversation that has not been had as should be. And in Kenya currently, the Kenya National Commission for Human Rights moved to the High Court to seek the recognition of intersex people. And in our last national census, the Kenyan one, there was a box for male, female, and intersex people. And now a task force was formed. So that task force came up with recommendations such as, we need to have a database on intersex persons, and they need to start being recognized, because you cannot be forced to be male or female. If you're intersex, you're intersex. So it opens up a whole Pandora's box of discrimination, issues of intersex people. I mean, and so I really support this effort, and I will try my best to find the link to the article because I wrote it in hard copy. Mm-hmm. And yes, I agree with Caster Semenya. I support her and everyone else who thinks that above all, this is a human rights issue. Just to add the last point, sorry to take so much time, let me speak quickly. You see, arbitration is a private process, I agree, in terms of it's not bound, because I also practice arbitration, it's not bound by any case law or any jurisprudence, so the tribunal decides on the facts at hand. However, on issues that touch on human rights, I dare say something like sports, when it becomes a human rights issue, it can't just be deliberated upon by just a tribunal, an ad hoc tribunal of 3 people, because this decision now will go and bind a whole industry, a whole bigger whatever, you know, these are things that should actually even go to international courts, supranational courts like the European Court of Human Rights, because it just can't be left to arbitration. A tribunal is just that. So yeah, those are my humble contributions, and thank you for having me.
Thank you so much for that insight from Kenya. That's much appreciated. I think I'll go back to Commissioner Advocate Ameermia. I think we heard now that the Kenya National Human Rights Commission also engaged with the issue, and there was this national census that created not the binary male-female, but inserted in there the category of intersex. I wondered if Commissioner Ameermia, you would like to respond just to the general human rights issues raised by other speakers, and maybe any reflections on the third kind of category and what the implications that would be.
Thank you very much. And perhaps if Commissioner Makwetla wants to add something, may I ask you to also ask her to make a contribution? But basically, it's all about the equality issues here. You know, the right to fair, for sporting practices, equality, and anti-discriminatory practices. Now, this falls squarely within the framework of business and human rights as well, the duties of the state, as well as the private organizations like the IAAF as well. So what we are saying is there are cross-cutting issues here that needs to be seriously dealt with. And obviously, if we look at people like Caster Semenya and many of the athletes from the developing world, they have really no money at all to go and challenge a big system like this anywhere in the world. I mean, for example, I must bring to your attention that the legal team in Caster Semenia's matter spent $1 million US to just make representation at the Swiss Court of Arbitration itself. Now, that to us basically says the following, that perhaps the South African Human Rights Commission, as an A-accredited institution, together with the sister Kenyan human rights, this thing through NUNRI, the National Alliance of Human Rights, should bring this to the forum on the agenda of the Global Alliance of National Human Rights Institutions, and then make representation direct at the Human Rights Council, so that we can address this issue once and for all. We can't have people who are big actors, trouncing over, the issues like that have been raised on Caster. I will just digress a bit. When Caster Semenya hit world headlines at the first time around, back in 2009, I was the chief director for sports, arts and culture in the Limpopo Provincial Department. And it was such a heartwarming experience because Caster was one of those girls who came from the villages and basically made her way in world this thing. And she was basically hailed as a hero. But when we went to her home, it was the most humbling experience I've ever had. And obviously, if we're looking at fair play, the question is, where does it start? It starts, at grassroots level. So I think in terms of the equality principles, the Human Rights Commission is very, very serious about taking this matter on. And that is why we said we cannot do it alone. We will also get the Gender Commission involved in this matter and knock at the doors of the Portfolio Committee of Sports, Arts and Culture, including the Portfolio Committee of DIRCO, to raise the level of, a multifaceted approach to this problem itself, so that we can all say with one voice, not to our athletes, because it's the African bloc at the moment that is also suffering from the impact of the decisions of these high-powered organizations.
Thank you very much, Commissioner Ameermia. I think one of the issues raised in the chat box was the distinction about sex and gender. Now, I think everyone who studies from a sociological, even from a legal point of view, these issues have been taught that we have sex, which is the physical appearance and physical characteristics of the person, and gender is the social construct, the role in which we forge ourselves and which society forge us, gendered roles, if you like. So the question is, how does this distinction now play? Does this distinction become irrelevant? Is it useless? Does it have any relevance to our discussion? I don't know, Bianca, that's a complicated matter, but perhaps you could try to address yourself at the observation that one of our participants made in the chat box around this issue.
Yes, of course. Well, if you go back to what I said in the beginning is, gender would be more of chromosomes. That's how they look at the chromosomes. That's when they will look at whether you have an X and a Y or a double X. And your sexual orientation is how you live your life. And in Caster's circumstances, it's very extraordinary because she does have an X and a Y, but she developed and identified sexual orientation was to be a female, and that's how she led her whole life. And especially coming back to the disadvantaged backgrounds that Mercy was talking about, it's quite important because especially in the African villages, medical assistance isn't readily available upon birth. So they just solely go on the sexual orientation, what the child looks like, what the appearance of the child is when the child is born. Whereas in Western culture, there is a lot more advantages in going to a hospital, being able to find out internally what the gender of the child is, what gender conditions may exist within the child. And that is also one thing that is not considered. And a lot of the time, Western children can be correctified by choice of a parent. But in African situations, they wouldn't know until we reach elite form of competition where that is classified. So a lot of these female athletes will only be told at age 19 or 20 that they live with this condition. They had never even known that that was their condition, and that's what makes it hard.
Thank you for those observations. Also, I thought I could call perhaps on Cole Barnes. Cole, I see you have made the point that there's considerable genetic variation among African populations, and that has an implication also for our discussion. Cole, if you could be willing to take the floor and make your point and elaborate briefly on that, please. Cole, perhaps let's just call you, not perhaps muted. If you are there, you could unmute, and I think perhaps, you know, otherwise I just refer us all to the comment in the chat box about the remark that because African populations show greater genetic diversity, clearly when one starts to look into these kinds of diversities, then you are bound to discriminate more against these particular populations around us. So maybe I ask if there are any members of the audience, by show of hand, if you use the function to show your hands, if there are anyone who would like at this point to make any contribution to the debate, that would be also much appreciated. Otherwise, for the moment, I'm going to take, okay, there is, I see there was Jill. Oh, Job Komakesh. Job Komakesh, you are welcome to take the floor. You can unmute and also open your video. Job.
Hello.
Yes, please proceed with a brief intervention.
Yes, this is Job. I work with the Center for Health, Human Rights and Development in Uganda. The questions that are being brought are very interesting questions, questions that Africa needs to unite behind it, and we shouldn't leave these fights to individual athletes, but rather we must take deliberate efforts to ensure that the rights of these athletes are actually protected, not just now, but even future issues that may arise. So for me, I look at the issue of caste and I already start thinking about the next 20 years to 15 on issues around participation when it comes to issues on sports. So for me, I think this is an issue that we should not just leave it to courts of arbitrations to handle them, but rather on as a continent and also support these athletes rather than leaving the individual fights to them.
Thank you very much, Job, for that intervention. I think Commissioner Ameermia also suggested we could give Commissioner Makwetla an opportunity. Commissioner Makwetla, please, we'd be very happy also to hear some views from your side, if you could join us and unmute and show us through your video.
Thank you very much, Prof. Now, my interest in Caster Semenya's case is how human rights, how sport can be used to promote and to protect human rights. And that is because our mandate is exactly that, the promotion and protection and monitoring of human rights. So we could not just stand by idly and not raise our voices when we witness Caster Semenya's rights being violated in this way. And I thank Commissioner Ameermia, for putting me into the debate and bringing on board the Commission on Gender Equality, because Caster is a positive, she's a very good role model for young girls in South Africa. She comes from a very humble, a rural background. She has worked extremely hard to get to where she, and sorry, I think I muted myself by mistake. I was saying that Caster is a very good positive role model for young girls in South Africa. And we need to protect her. She's a national asset. So I'm happy that we are talking about this matter, and that you know, she's got a firm of attorneys that is standing by her side and giving her support. Thank you, Chairperson.
Thank you very much, Commissioner Makwetla, also for that important direction in which our discussion should take itself. I noted that there was another concern raised, or an issue raised, that perhaps Steve and other panelists may want to comment on, and that is, in a sense, if we then take perhaps that the requirement, the regulation will stand, is one alternative to create different tiers of participation, different categories. Someone suggested that we could look at how it works in the Olympics for persons with disabilities, that one creates categories of being disabled or as living with a disability, and that that could be the basis on which we could now categorize also participation. I assume the analogy would be that on the basis of testosterone levels, we'll have various categories. Rather than talk about male or female, we'll say, you know, I suppose this is the category level of or related to testosterone. I don't know, Steve, if you want to elaborate on that as a possibility and also give us your assessment of any such thinking.
Thanks, Frans. It has been suggested, but exactly how one would define these categories would, of course, be problematic. In boxing, for instance, or even in sports such as wrestling, especially at age group level, it's not strange to have boys and girls wrestle each other because they go according to weight category. And at that age, there's not much of a strength difference. In fact, sometimes the girls are beating the boys if they are of the same weight category. So, no, not sometimes, actually often. So one way could be to define it, but then with a weight category, it's easy. You define the limits. But the question then is, if we do go that route and do away with this binary distinction, what do you use to define the different categories? And testosterone is flawed because, as I've said in the beginning, there are men who won medals at in the men's events who were hypoandrogenic. So in other words, they had about half the testosterone levels than one would normally expect of an average woman. And that really creates difficulty. So if we are going to have testosterone as the sole determining factor, we're going to have a huge disparity in the people participating in different events. I still firmly believe also that part of the reason why there's a difference between male and female performance, if we follow the binary distinction that sports federations make, is not only a physical difference, but it's also a societal difference that already arises in childhood. Because if we look at elite level athletes, even at the age of 11 or 12, where testosterone could not have had any significant impact, we still find that the boys outperform the girls in athletics. So the question is, where does that come from if we only say it's testosterone? And the only answer can really be that it's also up to, or at least that societal pressures play some role in determining that. So it's much more complex. And I think that's the big flaw with the IAAF, which I'm confident will eventually be exposed. If it's this year or 5 years or 10 years from now, but sooner or later, the scientific community will expose, it's actually already been exposed, that testosterone is simply a flawed way of trying to make the distinction.
Thank you very much, Steve. I think that we have Bianca making a contribution again. Bianca? Just unmute for us. Unmute, please. Just unmute your microphone.
Can you hear me?
Yes, yes.
Perfect. The only contribution I want to make there, specifically on opening up so that we can have different categories, either than the male and the female category, is you sit in a situation where you have a watered down category. We already sit with a crisis where female sport in general is less emphasized than male sports, which is why we sit in circumstances where females get paid less than male, because there's less interest in female sport when it's televised in the media. So when you're sitting in a situation where you want to create more than one category, the categories get watered down. And if we go look at the statistics at how many viewers there are of, let's say, the transgender Olympics, and how much, I'm thinking about the Afrikaans as aftrek, it will get compared
much,
to, support it would get compared to the normal athletics, the able-bodied athletics. It is just not in the same class range, and you don't want an athlete to feel like they are just being put in a category so that they can be doubted, so that they can be made quiet, and they will actually have no support in that category. So that's all I wanted to contribute to that.
Thank you. Thank you very much. I think just back to the issue of sex and gender, it strikes me that it really is a very complex matter if one looks at many of the issues involved. Sex, I suppose, had us look at the biological and the physiological of being, if you like, and it was comfortable with a very clear dichotomy of male-female. Gender told us, no, it's not about your biology, it's about your presentation. It's not about how you are categorized by your sex, but it's about how you present. And I suppose to some extent, the whole debate here is that the whole distinction between sex and gender does not really work as rigidly as perhaps we had ourselves believe. And that's part of the complexity and the interesting issues arising from this discussion for me. But perhaps in conclusion, I will ask each of the panelists really to just give us a little pounce, a little takeaway message of 1 minute or so, telling us perhaps how do we now take this forward? What kind of change, what issue will advance the cause that we're talking about here of caster semenya, but also of female athletes in this category. So perhaps I go the other way around. Tapiwa, I'm starting with you to just give us your view. What is one angle that could be explored, or any other takeaway that you would want to leave with the audience, with the participants, please?
Thanks, Frans. I think my last word will be it will be responding to the question that has been asked by Commissioner on how we can use sports to promote human rights. I think actually that is a very good conclusion to end this discussion, because we must also try to see the good in this, on how we can use this situation also to highlight the violations, the human rights violations against women with hyperandrogenism, so that the whole world is aware of this. So they're in countries where sports have actually been used, to countries which have gone to war and they've been unified by sports. So this could actually be one angle in which sport can actually be used as well. It's a clear one example in which that can also be used to promote human rights. Then also there's really need for like a lot of advocacy. So we shouldn't just be approaching the cause, all these platforms, but also we have to couple it advocacy strategies which complement any work that we are going to be doing. And there are perfect examples of like big corporations, companies which have done campaigns around the Caster Semenya issue. And for example, Nike, which is a very big company, they had their campaign just to eat Caster Semenya. But though this was mainly motivational, it would also take, it's an example that can also be used to promote human rights. I mean, to use sports to promote human rights. I think that's I have to say now, all I have to say.
Okay, thank you very much. Then perhaps we go, since Joshua had to leave us with his apologies, we go back to you, Commissioner Ameermia, for your concluding thoughts. Thank you.
Thank you very much, Prof. My concluding thoughts are the following. You know, 2020 is a phenomenal year for South Africa because we are now 25 years celebrating the establishment of the Human Rights Commission. And in October this year, 2020. So my take-home message is the following: that we must never allow ourselves to be humiliated by anybody and suffer the indignities that Caster has suffered. And therefore we must embark on strategic impact on two fronts. One is advocacy and awareness. And so in other words, we must maintain the momentum that we are a universally recognized human rights country because it's entrenched in the Bill of Rights. But secondly, where our rights are threatened, like it has been done in Caster's matter, that we will stop at nothing and do strategic impact litigation in the public interest to ensure that justice is done. And so we have that accreditation status at the United Nations as an A-accredited body. We will do everything in our powers, not only to protect her, to protect every vulnerable athlete that has to go, unfortunately, who had to unfortunately go through the humiliation and the indignities that Caster had to go. So that's my take home, this thing, that we will support her, protect her, and promote her as a national asset, as Commissioner Makwera said. Thank you very much.
Thank you so much, Commissioner Ameermia. Professor Cornelius, your conclusions and takeaway message.
Thanks, Prof. Viljoen. In the text, I shared the principles of Olympism, which is from the Olympic Charter. And I hope it doesn't become like the principles of animalism and Animal Farm, that we say all athletes are equal, but some are more equal than others. But if you look at the principles there, it refers to fundamental ethical principles. It refers to a harmonious development of humankind, promoting a peaceful society. It refers to sport is a human right. It refers to practicing sport without discrimination, and so on. And all these principles are there. And perhaps we should also, especially from the human rights bodies that are here today, engage directly with the Olympic Committee and ask them, but how is it that you promote these in your Olympic Charter right at the outset, and you allow members to actually discriminate? And for me, the worst part of these regulations is not the fact that it might be discriminating or not discriminating. It's the fact that you are coercing people who are healthy, who do not need medical treatment, and you are coercing them into a medical intervention that we don't know what the impact of that would be on their health. If a national government did this to individuals, there would be very strong grounds to take action, even at the International Criminal Court. And here we allow a sports federation to do that, and it should stop.
Thank you so much for those powerful statements, Steve, Professor Cornelius. Bianca, as our last speaker, rounding up, please.
Yes, so I'm just going to end off with quoting a piece of my research. Basically, I say the law should encourage Paralympians to compete with able-bodied athletes, cease from constituting and enforcing a term genetically cursed, and most importantly, prohibit concepts of purity and fair sporting practices to overpower the protection of athletes against dangerous products and practices in trying to achieve anti-doping goals.
Okay, thank you for that. Also leaving that in our midst. It is really for me to also just add my voice. I hope that everyone got an interesting perspective and some added, if you like, ammunition in the fight, if we use that metaphor. Certainly for me, it was very interesting to just be made aware of Resolution 40/5 of the Human Rights Council, which now leads to a report by the Office of the High Commissioner for Human Rights, which I think many of us can utilize. There were many interesting and important points raised. Thank you to all our panelists. We really appreciate it. We know that there are many demands on your time, and we really found it very, very useful that you were here and that you made these contributions that you were able to make. Thank you also to our audience. These events are only meaningful if there are people listening in. We know also in your case, there are many contending demands. We thank you for being with us. This is part of the Center for Human Rights weekly talks on a Tuesday at 11. We also have talks on a Thursday at 11 as webinars. Usually the talks are around COVID, but I think it was quite refreshing, perhaps you agree with me, to just take some air and not being submerged into COVID-19 discussions, at least for a few hours, I think was also salutary. I just draw your attention to the fact that this webinar has been recorded. We'll share with you a recording, so if you want to listen again or share it further, and I certainly invite you to be a part of any of the future discussions, webinars from the Center for Human Rights. You are part of our mailing list. We will keep you informed. We will now also show you again a poll, as you did at the outset. We ask you in this poll just to indicate your preference or the benefit that you experience from this meeting. So the poll, I think, will be shown, and before you leave, we will just ask you to fill this out. I think there it is. So there are two questions, as you see, very quick and easy. Just choose, has the talk on hyperandrogenic women in competitive sports met your expectations? Yes or no, it exceeded, it met my expectations. And then the second question, just like, what was the most valuable aspect of it for you? You can choose any of those. If you would just support us and just tick and complete these as well, that you could assist us in taking our webinars in the series forward. So once again, to the panelists, to the participants, thank you so much. We trust that collectively we are better equipped, more inspired to take on in our own ways, wherever it's possible, the issues that I'm sure concern us all. As a Center for Human Rights, certainly we are concerned, and we are also exploring ways in which we can add our weight to the many efforts that are there to bring the human rights implications of what is happening here to the fore. Once again, thank you. Have a nice day. We hope to see you again soon.